everybody, this is Aishley Verma, an intern with LEXIS and Company, and today in this video I will be dealing with a case named Pawan, Pratap, Singh and others versus Reevan, Singh and others. The citation of the case is Civil Appeal number 9906, 9907, 9908 of 2003. It was appealed in the Supreme Court of India, and the bench consists of Justice Aftab Alam, Justice R.M. Loda. The date of the judgment is February 10, 2011. Talking about the head notes of the case includes gazetted service rule 1908, UP's government servant rule 1991, and article 14, 16, 226 to 309 of the Constitution of India. Talking about the facts, so the facts of the case includes that the UP Uttar Pradesh jail executive subordinate, that is non-gazette service rule 1980, was framed by the governor of the state in exercise of the powers conferred by the proviso of article 309 of the Constitution of India. Rule 5 of the 1980 rule deals with the recruitment to the post of deputy jailer and assistant jailer in the service. So the recruitment was done by two processes. The first is by direct recruitment and the second is by promotion from amongst the permanent assistant jailers. So Rule 15 provides the procedure for the direct recruitment of all the posts for the deputy jailer and assistant jailer. So talking about the facts, so there was a notification on December 26, 1987 for the combined lower subordinate service examination 1987. Further, it was mentioned in the advertisement that there was approx 600 seats, but it was ambiguous. Further, there is a dispute of the fact about the factual vacancies in the cadre. So there was no clear-cut number of seats availability notified. The Uttar Pradesh Subordinate Selection Commission was enacted by the UP legislature to establish a SSC for direct recruitment to all the Group C posts in the state of UP. Also, the Act of 1988 came into force on February 15, 1998. On November 25, 1989, a notification was issued by the Governor of UP clarifying the number of vacancies referred to the UPPSC shall be filled by the recommendation of the UPPSC only. So it was notified by the Governor. On October 27, 1990, the Selection Commission advertised and notified for the filling of 60 posts of deputy jailer by a competitive exam under UP Karpal examination 1990 shall be held. So there was exam held and there was oral interview also, and the Selection Commission issued a list to the state government in 1991 for the appointment. Further, on November 23, 1991, the state government issued appointment letter of the candidate that are selected by the selection committee. So state government has also done its duty. The present appellant in civil appeal number 9906 of 2003 and civil appeal number 9908 of 2003 were amongst those who were appointed by the state government pursuant to the selection committee. In 1991, the UPPSC also conducted a mains examination for filling the different posts of Group C, including the post of direct recruitment of deputy jailer. So the result of that examination came on 27th July 1993. The UPPSC then sent the selection list to the state government. The state government again issued the appointment letter to the candidates who were selected in such examination on 26th April 1994. Further, the private first respondent was one of this selection committee candidate. Further, the Uttar Pradesh government servant seniority rule of 1991 was framed under the proviso of Article 309 of Constitution of India, and it was given effect from March 20, 1991. So on 29th August 1995, a tentative seniority list of deputy jailer was notified by the Inspector General of the prison, the appointing authority. He was the appointing authority, and objections were also collected from the concerned officers. In that list, the candidate appointed in 1991 were shown senior to the candidate appointed in 1994. The litigation between the two groups started with this list. The tentative seniority list date is August 29, 1995, came to be challenged before the Allahabad High Court in the three writ petitions. One by Bholanath Mishra, writ petition number 26560 of 1996. The other is by Samar Bahadur Singh, writ petition number 13138 of 2000, and the third is by the first respondent herein, which is Reevan Singh, writ petition number 22919 of 2001. The writ petitions filed by Samar Bahadur was dismissed by the High Court on the ground that availability or alternative remedy before the State Service Tribunal, and the writ petition filed by the first respondent herein was allowed on December 2, 2002. And the High Court directed the State of UP and the Director General Prison, Lucknow, to treat the appointees of 1994 senior to 1991 appointees. The division bench held as follows. So this was the judgment of the High Court, that in our opinion the correct interpretation of the proviso to Rule 5 of the UP Government Servant Rule 1991 is that persons like the petitioner who were selected in the selection process which commenced in 1987 should be treated senior to their to their seniors who were selected in process commenced in 1990. So the High Court held that 1991 rule will prevail over 1980 rule if there is any conflict between the two rules. So lastly, being not satisfied with the judgment of the High Court dated on December 2nd, 2002, 3 appeals were by special leave had been filed on one by the state of Uttar Pradesh and 2 by 1991 appointees. So talking about the issues, so issues which are included in this case are 2, that whether the appeals are maintainable, three issues. First is whether the appeals are maintainable, second is whether the petition filed by the respondent number 1 maintainable, and third is whether Rule 5 can be applied instead of Rule 8 of the 1991 rule for the purpose of determination of seniority. So let's talk about the judgment. Here, if we talk about the judgment, so the court held following judgment. For the foregoing reasons, these appeals were allowed. The judgment and the order dated December 2, 2002, passed by the Allahabad High Court, is set aside. The seniority of the two groups of the direct recruitment to the post of deputy jailer, one appointed through the selection made by the Uttar Pradesh Subordinate Service Selection Commission in 1991 and the other by the Uttar Pradesh Public Service Commission in 1994, shall be now determined as indicated above, if not determined in the manner stated above. So far, there shall be no order as to cost. Also, in the view of the two separate judgments which are concurrent in nature, pronounced by us, that is the judges, in these appeal today, the appeals are followed. There shall be no order as to cost. So this was the judgment held in this court. Hope you liked the video. Thank you so much.